Hi, everyone, and welcome to Conn Maciel Carey's webinar on managing internal investigations. My name is Lindsay DeSalvo. So before we get into the substantive discussion, we'll just take a second to introduce ourselves. As I said, my name is Lindsay DeSalvo, and I'm a partner at Conn Maciel Carey in both the firm's employment practice as well as our safety and health practice. And, as it pertains to our discussion today, I have extensive experience in assisting our clients, both from the employment perspective and from the workplace safety and health perspective, with internal investigations, when complaints are received, either supporting clients through internal investigations, advising on internal investigations, or actually conducting the internal investigations myself. And related to that, I also spend a lot of my practice counseling and advising employers on the types of policies and practices that should be in place to potentially, avoid the situations where a complaint is filed, but if a complaint is filed, ensuring that there is a process in place to respond to that complaint, investigate that complaint, and ultimately come to a determination. And I will pass it over to my colleague, Ashley Mitchell, to introduce herself.
Thanks, Lindsay. Good afternoon, everyone. As Lindsay said, I am Ashley Mitchell, and I am an attorney in Conn Maciel Carey's Chicago office. Like Lindsay, I practice in both our OSHA and labor and employment practice groups. And as it relates to this afternoon's webinar, I do also have experience in reviewing employer policies and procedures with the hope and goal of certainly avoiding any complaints that would necessitate an investigation. And I also have experience in participating in and responding to complaints that would necessitate an internal investigation. And those include responding to, EEOC complaints of discrimination, as well as OSHA complaints, related to workplace safety and health. And so with that, I will turn it back to Lindsay for today's agenda.
So we're going to try to cover quite a bit of material today, but it's sort of really three main areas that we want to touch on. The first is setting the scope and goals of internal investigations. So, before we actually start conducting an investigation, and even before we really put in place a plan for an investigation, the first step here of setting the scope and goals is really important because it sort of frames out all the necessary steps and processes that are important to implement as part of the investigation. Then we'll spend some time talking about the initial steps in conducting an investigation. So actually getting an investigation plan in place, determining who needs to be interviewed, what documents you need, things like that. And then finally, we'll close out with discussion around some special considerations, things that commonly come up during an internal investigation, like attorney-client privilege considerations, particularly in our current environment, conducting internal investigations when people are both in office as well as remote, so how to navigate some of those issues as well. And I will pass it back over to Ashley to start us out with the first discussion topic.
Thanks, Lindsay. So as Lindsay mentioned, first on today's agenda is setting the scope of an internal investigation. One of the first steps in setting the scope of an internal investigation is determining whether this investigation will be informal or formal. And so when making this determination, you will want to consider the nature of what is in fact being investigated. For example, you may consider conducting an informal investigation if the investigation is related to minor policy violations where the issue can be resolved quickly without many interviews or without, speaking with very many witnesses. Informal investigations are also a good tool when you are trying to determine if a complaint or workplace issue has merit. For example, if the issue was raised by a less than credible source, in my practice, I have seen it where an employee is in the process of being disciplined and possibly terminated. And so to add a wrinkle to that plan, they might raise safety concerns that aren't really present in the workplace. For example, they may allege that they don't have the appropriate personal protective equipment when the employer in fact knows that they have done a very well thought out hazard assessment and no PPE is required. Nevertheless, the concern has been raised and you certainly might want to look into that. So you might consider that to be a good instance for an informal investigation. Another example could be, now that folks are coming back into the office and that water cooler chatter is starting back up, it is possible that the office rumor mill is also starting back up. And so to the extent that someone has heard a rumor alleging, misconduct, at this point, it could very much so just be a rumor from folks coming back into the office. And so before launching into a formal investigation, you might consider having an informal investigation to determine if, there's any merit to that allegation. In contrast, you may consider conducting a more formal investigation where there is potential legal exposure or a policy violation. So formal investigations could be triggered if there is a complaint or report of a policy violation, even if the person making that complaint insists that, you do not investigate. If they just come, I have this concern, I'm just raising it, I just want it to be on record, I don't want you to do anything with this information. Well, certainly want to hear their concerns about why they don't want anything to be done with that information. But if they are making, serious allegations such as sexual harassment, that is certainly something that could warrant a formal investigation. Likewise, if a manager observes a violation of a workplace policy, that is something that could warrant a formal investigation. And now is a good time to point out that it's important to ensure that managers understand if they see something that they think, violates a workplace rule, violates company policy, or even has the appearance of an impropriety, they should absolutely say something. Likewise, you might conduct a formal investigation after a workplace injury or illness. If there's been, an EEOC charge, an NLRB charge, or a lawsuit, again, you might consider a formal investigation for a DLL audit, or if there is theft of company property. And so on this next slide, we are going to look at the need for those formal investigations more closely. So the answers to the questions on this current slide may be used to determine if a formal investigation is needed. So the first one being, how serious is the policy violation or conduct? And here, you think about it as a sliding scale. The more serious the complaint allegations, the more likely it is that you should be conducting a formal investigation. That second question, how many employees are involved? Again, a sliding scale. If there are a greater number of employees involved, it is more likely that you're going to want to perform that formal investigation and make sure that, you're keeping accurate track of any witness statements, interview notes, and any documents that come about as a result of that investigation. And that next question, is there an immediate threat to loss of company information or danger to employees? If there's a potential threat of loss of a trade secret or proprietary information or potential danger to employees, you are going to want to promptly begin, that investigation process. And depending on the nature of the threat, it might be advisable to get in touch with your counsel, either in-house or outside, immediately to determine what proactive steps may be taken for the protection of proprietary information and trade secrets, for example. What areas of the law are implicated may also inform your decision about whether or not to conduct an informal or formal investigation. Under certain federal statutes, a formal investigation is required. So, for example, discrimination laws like Title VII, the ADA, and the ADEA if the employer can show that, they exercise reasonable care to prevent and correctly prompt any harassing behavior, and the employee unreasonably failed to take advantage of the opportunities provided by the employer, in the event of a lawsuit, then the employer may be able to raise the affirmative defense that is referred to as the Farger-Ellis defense. Likewise, under the OSHA Act, employers who not only have a work rule, but effectively communicate that work rule and can show that they are actively enforcing the work rule, including visually observing employees following that work rule and investigating allegations that the work rule is not being followed, and are able to show, written records of those investigations and potentially discipline to employees who violate that work rule, if there is a subsequent OSHA inspection that results in a citation being issued, an employer could assert, the affirmative defense of employee misconduct. Some other statutes to keep in mind are the Sarbanes-Oxley or SOX, which requires employers to review complaints and investigate allegations of fraud. DOT regulations, which require employers to check and verify driver history. Under HIPAA, healthcare companies can incur civil liability or exposure if they do not investigate allegations of wrongdoing. And so in each of these examples, depending on the nature of the complaint, it could be helpful, to reach out to your in-house counsel or your outside counsel to really determine the best way to go about conducting that formal investigation, documenting that formal investigation, and then, as we'll discuss later, making sure that those investigations are conducted under privilege, so that any information discovered during your investigation won't be used against you. And then finally, does the investigation need to be completed immediately, right? So if the complaint that's triggering the investigation is serious and time sensitive, then it would be suggested to open a formal investigation, prioritize your efforts, and get started on that investigation immediately. Some other considerations for investigations, for these formal investigations, would be considering the number of investigators. And I know Lindsay is going to provide insight on how to determine who should participate in the investigation and the role of each investigator, but I do just want to give a little teaser here and mention the importance of having, one or two investigators, potentially one as a note taker and the other as an interviewer. Some other considerations are locking in witness stories and recollections. The sooner, the better. People have short-term memories. There's a lot, going on. And so the closer in time to the alleged incident that the interview happens, the more likely that witness is to remember the details of, the questions they're being asked. Likewise, witnesses may leave the company. And so it's also important to make sure that you are getting any sort of knowledge or institutional knowledge that they may have before they have the opportunity to transfer divisions or leave the company altogether. And with that being said, a quick note here to ensure that you have the most up-to-date contact information for each of your witnesses in the event that they do transfer divisions or leave the company to pursue other opportunities. You want to make sure that you are able to, get in contact with that witness should you need to in the future. Likewise, you are going to want to preserve documents, emails, text, any data that can be lost or destroyed. So along with preserving those documents, you're going to want to ensure that you are collecting and preserving all potentially relevant evidence. And so, as the initial stages of the investigation, it is better to cast a wide and broad net when you are looking for that data, whether it be a written document or something that is preserved electronically. For example, if there might be security cameras at your facility that could have potentially captured the incident, to the greatest extent possible, you are going to want to back up that security camera footage before it is automatically deleted. maybe at a later date, you determine you don't need all 12 hours of the security footage and it's not relevant. But as you are starting out, before you make that determination, to the extent possible, cast a wide and broad net. And if you are, and thinking about these considerations, again, reaching out to your in-house counsel or outside counsel and having them involved in the decision-making related to preservation efforts. And the reason being, if the incident or complaint that gave rise to the investigation results in a lawsuit, if it is determined that the evidence was not properly preserved and therefore that evidence is not available, throughout the lawsuit and at trial, the company will be subject to an adverse inference about what those documents and information may have shown. And so to prevent, that spoliation and potential adverse inferences at trial, in the initial stages, casting a wide and broad net about what documents and information you are preserving. And likewise, that ties into, ensuring compliance with any legal duties you have to maintain relevant records and information and to investigate the complaint allegation promptly and thoroughly. And so with that being said, we've talked about formal versus informal investigation. It's also important to think about at these beginning stages of an investigation, the goals, regardless of whether you're conducting, an informal or formal investigation. Each investigation should have clear goals. The most important and primary one being evaluating whether the allegations themselves have merit. And if it is determined that the allegations are meritorious, what are the next steps? Should disciplinary action be taken? Is there a work rule that needs to be updated? Do employees require additional and new training? You are going to want to make sure that you are documenting any sort of corrective action that is taken as a result of, the investigation. And then you're going to want to make sure that not only is that corrective action documented, but that it's communicated to the employees who need to know. So for example, if the investigation determined that there was a workplace rule that needed to be updated, after the rule is updated, it's important to make sure that, you don't just update the policy document and then stick it in a binder, but there's actual communication to employees who are affected by this workplace rule about the changes that were made to the rule, how employees are now expected to conduct themselves in the workplace, and give employees the opportunity to ask any questions to make sure that they fully understand the new work rule and how it impacts them. This additional step of communicating corrective action to affected employees can also improve employee morale, productivity, and reduce employee turnover rates. By documenting any sort of corrective action that's taken and how it's communicated to employees, again, it can also serve as the basis for an affirmative defense if there's subsequent legal liability, or in the alternative, updating that workplace rule, letting employees know that you hear their concerns, you are listening, and you are actively taking steps to protect them or to address those concerns could avoid potential litigation in the future. And so on this slide, we're just going to explore the concept of mitigation in greater detail. Considering what mitigation may be required based on the nature of the complaint and what corrective action may be required if the allegations are meritorious could inform the entire investigative process. For example, in the scenario laid out here, where there's a complaint of sexual harassment by a direct supervisor, during the course of the investigation, you may consider whether the alleged victim should be assigned to a different supervisor while that investigation is being conducted, or whether that direct supervisor should be suspended pending the outcome of the investigation. Those are two examples on the spectrum, but if possible, you may consider other ways to limit the interaction between the alleged victim and the individual that they are accusing of misconduct. As you are thinking about these mitigations, it's important to remember that there's more than one way to remedy the situation. So there's not going to be a one-size-fits-all, and you should certainly take into account and consideration the nature of the allegations, the interaction between, the person making the allegations and the person who is accused. And it's important to address these mitigations in a very thoughtful way. For example, if the decision is made to reassign the alleged victim, you will want to make sure that that victim does not feel that they are being retaliated against for reporting the misconduct. And so important considerations here include whether the alleged victim is being reassigned to a less desirable workstation or a less desirable work shift. You may also consider whether the reassignment would constitute a demotion in work responsibilities, or if the reassignment could have an adverse impact on the alleged victim's ability to be promoted and advance within the company itself. And so now that we've discussed the nature and scope of the investigation and potential mitigation considerations, before I turn it over to Lindsay to discuss the nuts and bolts of the actual mechanics of how the investigation works, let's discuss the elements of an internal investigation. It's important to make sure that your internal investigation is prompt. Once that concern, complaint, allegation is raised, once you receive that EEOC charge, you want to promptly respond, but you do not want to be rushed in your investigation. You want to ensure that the investigation is thorough, but not too long. And so essentially you are balancing timeliness with being thorough. You're going to want to consider business needs. This investigation is certainly important, but you are going to want to you're going to want to take into consideration employee morale and how witness interviews could potentially affect productivity, or maybe put employees on edge if the interviews are taking too long, if the investigation process is, the same employee being interviewed time and time again. So you're going to want to make sure that you're being thorough, but, not taking too long. You want to maintain confidentiality to the greatest extent possible. Now that you might not always be able to maintain confidentiality. For example, if someone has broken the law, you may be required, depending on the law, to report that violation, that fraud, to the appropriate federal agency. But overall, you want to keep the investigation, the results, the outcome, and any interview questions on a need-to-know basis, such that you're not broadcasting it to the entire workforce. You're going to want the people who are conducting the investigation, not just in the driver's seat in determining who needs to be interviewed and when, but also those who are conducting the interviews, that they are impartial and objective. There should be no bias in conducting investigations. And so even if there is an appearance of bias or partiality, you will certainly want to take that into consideration. You can do this by having the investigations conducted by a disinterested and respected third party. Because again, with investigations, it's important that there is not even a perception of bias. And so you can avoid this by not including anyone who's involved in the complaint allegations or the incident that triggered the investigation in the investigation, even if it is a part of their formal job duties. Whoever's participating in the investigation should be effective at facilitating an appropriate outcome for all sides. And so overall, the goal is to figure out what occurred and how to remedy what occurred. And so you want to ensure that the persons who are participating and directing this investigation have the ability to make determinations about remedies for any issues that might be identified. And so with that, I will turn it over to Lindsay, who can discuss the actual steps in conducting the investigation.
Thanks, Ashley. So once you have your goals set, you decide to sort of, how to proceed as far as using an informal or formal investigation process. The next step that you're going to take is outlining a plan for the investigation. And you'll see here, the way we kind of think about this. There's a lot of different considerations here. So Ashley already talked about that first step, identifying the scope and the goals. The next step that you're going to want to take is outlining the elements of the claim. And this, for, again, more minor policy violations, this might be really basic and straightforward. If it is, more of a quote unquote legal claim, a violation of Title VII, for instance, or a violation of the Americans with Disabilities Act, where the elements of the claim are really, set by case law and pretty standardized. Certainly legal counsel will be involved in some way. And so it's important to consult with them at that point about sort of what are the elements here? What are we specifically looking for? Because this is going to dictate the types of questions that you need to ask during an interview. It's going to dictate the types of documents that you need to be able to collect and review. And then once that's set, it's identifying the investigator or team of investigators. And we'll talk about some of these in a little bit more detail on the slides that follow. But the investigation team is really important and will really depend on the type of complaint that you are addressing or the type of claim you are addressing. Again, more minor policy violations, it's a little bit more simple and straightforward, but if you have a claim for violation of wage and hour law, whether that's state level or the Fair Labor Standards Act, that could require the help of an outside consultant who needs to evaluate pay practices. And so, it's identifying who really needs to be on the team based on the type of claim or complaint that you are investigating. Next, putting together a plan. Sorry, Ashley, you can go back to, thank you. The next piece of putting together the plan is deciding which documents you might need. In the case of a complaint of harassment, for instance, you might want to immediately obtain the personnel file of the accused individual to determine whether there's been any prior complaints. That feeds into the next point too. Are there prior complaints or similar complaints about a particular person or involving a particular person? That would be helpful context in determining sort of whether there is any need to be aware of those things going into this investigation. And we'll talk a little bit about that in more detail in a later slide. Then it's, sort of putting together some plan for maintaining an investigation file. The investigation file is going to be really important. Not only, and Ashley already talked on this, talked about this a little bit, but not only from the perspective of, being able to use it as a potential defense if this complaint is brought to a federal agency or outside the company, but also for your own purposes to establish that an investigation was conducted, to establish who was spoken to, what was looked at. It's really important to maintain that documentation and have a plan in place for who is collecting that documentation, where it's going to be maintained, and who it will be accessible to. Then considering external resources, this will go into who might actually be conducting the investigation. And even if this person's not going to be conducting the investigation, who else might you need to involve in these discussions? And then finally, a plan for how the investigation will be closed out. And this is important to think about right in the beginning because it dictates how you are going to be collecting documents and information and how you're going to be analyzing those things and whether that will be done in writing. We generally do, suggest documenting the investigation, whether that is putting together a final investigation report that really just sort of lays out, again, who you talked to, the documents you looked at, the content of the interviews that you conducted, so that there is sort of one location where there is an assessment done based on all the different forms and types of information you collected and what was learned throughout the process. Then developing a message to share the outcome of the investigation, deciding who you need to share the outcome of the investigation with and how that is going to be messaged. Again, something really helpful to think about right in the beginning, because it does sort of play into your interactions with those you interview, the complainant, the accused, throughout the investigation. And then finally, having at least some preliminary idea in place of how you're going to contact the complainant and the accused at the end of the investigation. If it's a situation where there is a particular accused person, what is going to be communicated to them, who is going to make that communication. And as Ashley already touched on, we definitely do advise communicating the outcome of an investigation. Because I can say from my experience, where the outcome of an investigation has not been effectively communicated to a complainant, for instance, it's more likely to result in them feeling like they need to go outside of the organization to get a resolution of their complaint. So it is really important to take that step, but generally the information you're going to share is pretty limited, that the investigation has been completed, that steps will be taken to address the concerns raised by the complainant. And, to the extent the complainant is going to be involved in any of those steps, you can certainly inform them. But, it's going to be a pretty limited communication, but it is important to make sure that they know that the investigation has been concluded, and findings have been made. Next slide. So who should investigate? As Ashley discussed already, for minor violations of policy, that's going to be sort of the more informal investigation process. And those are the types of situations that we're generally going to rely on human resources to investigate. Your personnel and human resources has the best knowledge of the policies and practices in place, how they should be complied with. And so that's usually the effective resource for those more minor violations of company policy for those individuals to conduct the investigation. And even where it is, where it is human resources who is conducting the investigation, it is helpful to have someone who can actually ask the questions, and sort of have the back and forth with any interviewees that may need to be spoken to as part of the investigation, and have someone else who can take notes on that. For more minor policy violations, it's not necessary all the time to do that, because maybe you're speaking to one or two people, they're pretty short conversations, maybe it's not very intensive. And so resource-wise, it might not always make sense in those situations to have two people, but it can often be really helpful to make sure that whoever's doing the actual questioning can really focus on that piece, and that there is, a supporting witness to sort of, be able to corroborate what the investigator said they heard and determine based on the interviews. So in many cases, though, particularly with more potentially serious violations that could result in litigation, you definitely want to make sure that counsel is involved. And that could be either in-house counsel or an outside attorney, depending on the circumstances. And I'll talk a little bit about what goes into making that determination. But part of that can certainly be, whether there are any business implications for this investigation. There tends to be, a feeling that in-house counsel, has more of a business association with the company that they're working for as well. So that can sometimes be seen as impacting an investigation, and maybe could potentially take away from the attorney-client privilege nature of the investigation. So that's something that is considered in that context, as well as sort of, and this goes to the next one too, having an objective outside opinion of the facts surrounding a complaint. So that can be a really good place to bring in outside counsel, particularly, for these cases that might go to litigation, to have that attorney-client privilege protection. But then it could also be the case that an outside consultant or investigator might be appropriate, particularly if it is sort of a more technical, unique situation where their specific experience and expertise might be really useful. We see this sometimes in our practice in the safety context. If we're investigating, a safety complaint or, an allegation that a guard is missing or some policy should have been implemented from a safety perspective, it can be helpful to have an outside consultant come in and really evaluate that situation because they have more expertise and technical knowledge in that regard. You may also want to involve a forensic examiner in the investigation. And this is going to often be the case where you have a situation that there's a threat to the proprietary information of the company, or as I previously mentioned, if you have a wage and hour claim that is more complex, maybe involves a lot of employees at the company, and there needs to be a real thorough analysis of pay practices, that's where it can be really helpful to bring in that type of third party to assist with the investigation. And then finally, I think these are the rarer instances, but it can be appropriate to bring in a law enforcement support for an investigation in the case of, a violent event that occurs in the work environment, or potentially a theft, depending on the type of theft. But that is not something we see as often, but that is certainly something to consider in those specific types of cases. So the next slide, we dig into a little bit more whether an attorney should conduct the investigation. And as I previously mentioned, it is useful to bring in an attorney to conduct an investigation where there is likelihood that the type of complaint, a harassment complaint, for instance, a discrimination complaint, for instance, could go to litigation, because bringing in an attorney then allows you to assert attorney-client privilege and attorney work product protections, which give confidentiality to the outcomes of an investigation, the findings of an investigation, and the work product that is assembled pursuant to the investigation when it's conducted by an attorney. The main times that we're going to, really suggest that an attorney investigator be considered is, again, if it could result in litigation, but also in situations where the investigation is likely to reveal information that could be harmful to the company. Because again, you have that added layer of confidentiality and protection over the findings of an investigation that can be asserted to sort of shield that information from having to be shared if it goes to litigation. Because when things go to litigation, you have discovery, the opposing party or opposing counsel can ask for these types of documents. And so to the extent that you can claim protection and privilege over them to withhold them from production, that can be really helpful. And then ultimately, if it's determined that it would be useful to share certain information from an investigation, then you can decide whether to waive the privilege. And in that case, you can say, all right, you know what? We want to be able to show the EEOC that we thoroughly investigated this claim of harassment, that we took steps to address any findings from that investigation. So we're going to waive our claim of privilege and we're going to share the results of that investigation. Next slide. So once you've decided whether it'd be appropriate to have an attorney involved, and in-house counsel is often, I think, involved in that assessment, then it's deciding whether the investigation should be conducted by in-house counsel or outside counsel. And these are just some of the considerations that we suggest kind of going through at that preliminary stage where you're really trying to decide, who should be on the investigation team, what your process is going to be for conducting the investigation. As I mentioned previously, in-house counsel could be perceived as conducting the investigation primarily for a business purpose. And if that perception exists related to an attorney-client privilege claim, that can tend to go against whether you really can claim attorney-client privilege over something, because in those circumstances, opposing counsel might assert that really this individual was involved from a business perspective, so there should be no claim of attorney-client privilege. It's not appropriate here. And in that circumstance, it's helpful to have outside counsel involved because they don't have that same potential perception of being involved primarily for a business purpose. Concern with perception of bias. That's another instance where it can be helpful to bring an outside counsel because, again, the in-house counsel doesn't necessarily work with the individual employees, particularly in larger companies, on a day-to-day basis. But there's certainly, if there are some issues, with those particular employees and other managers, there can be a perception that there is some bias in how we want the investigation to come out. And so having someone who is not at all involved in the company come in and take sort of an objective perspective can be useful in showing that bias was certainly not a piece of the ultimate outcome of the investigation. If it's something, again, that is likely to go to litigation, the interviewer is likely to be called as a witness during litigation. So that's another circumstance where having outside counsel conduct the investigation is useful, because then in-house counsel can still serve as counsel for the company, while not having to worry about, being put on the stand because they were the ones that conducted the investigation. That could be the outside counsel who was brought in for this purpose, could be provided as a witness in that situation. And then finally, if there's a need for particular expertise or experience that is not possessed by in-house counsel, we definitely experience this in the context of workplace safety, because not a lot of people have experience in workplace safety. That is definitely an up and coming field of law, I think. And so it might be the case that it's helpful to bring an outside counsel who has experience, who has done this type of litigation before, who understands these issues a little bit more, to conduct the investigation because of that background. So once you sort of have a plan in place, you're going to go ahead and start conducting the interviews. And it could be, again, for the more minor policy violations, this might be just a couple interviews, but where you have, a more complex issue or an issue involving potentially more parties, this could be quite an undertaking. So it's really carefully considering who should be part of the interview process. And you're going to want to interview whoever filed the complaint, whoever is accused of engaging in the particular misconduct based on the complaint, any witnesses that are identified by either of those parties. You may also want to interview management, whoever is the manager of the accused or the complainant, to see if they have any additional information related to the particular claim. If HR has been involved in dealing with the basis for the complaint prior, we see this sometimes in the context of a harassment claim, for instance, if there's been sort of repeated issues where you have an individual employee who is bringing a lot of, different complaints or different concerns to HR is dealing with them, and then all of a sudden they filed a more formal complaint against this particular person. You want to be able to interview HR to discuss, these prior complaints, as well as sort of any meetings or discussions that were had around those prior complaints. And then finally, if there are any experts within the company, you may want to speak to them as well. Again, going back to the safety context, if you do have, a safety manager or someone who has particular guarding expertise or lockout tagout expertise, and that's part of the complaint, then you want to speak to that person as well to sort of get any helpful information you can from them. Typically, what we recommend is interviewing the complainant first, then the individual that's accused, then any witnesses, and after that, going back to the complainant based on the additional information that you've received throughout the interview process. A lot of times it might also make sense to re-interview the accused at the end of sort of the initial interview process, just again, to maintain that perception of fairness. If there are other things that are coming up in the course of the interviews, that you're giving the accused a chance to respond to those specific allegations or specific facts that they may not have been able to speak to initially. And then you're sort of, again, taking notes on these interviews, documenting these interviews, and making sure that the content of the interviews is really set out and maintained for purposes of making ultimate determinations, but also supporting a thorough and objective interview process. Really quickly, the rights of the interviewee, they're generally not going to have a right to counsel unless that is a case where they could be facing possible criminal charges. But in most cases, there's not really going to be a right to individual counsel. The right to having like a friend or support person present, that's not really a right in most circumstances, but it could be the case if you have an employee who may not be comfortable with the English language, having someone who could translate could be helpful for an interview process. If it's a particularly sensitive situation, having, a manager present might be useful, or a coworker present might be useful to facilitate the conversation. But in a lot of cases, you're going to want to limit who else participates in the interview, particularly where you are trying to maintain attorney-client privilege. There could be a right to union representative being present, depending on the specific requirements of the collective bargaining agreement, if it speaks to that at all. There's also something called wine garden rights, which allows an employee to request that a union representative be present and have them be present if the interview is about that employee's performance or work conduct, and that individual reasonably believes the investigation could result in their discharge, discipline, or demotion, or another adverse consequence to them. Next slide. So Ashley already talked a little bit about this, so I won't spend too much more time on it. But these are the types of documents that you are likely going to want to collect as part of the investigation process. And as Ashley mentioned, you're going to want to start pulling these things right in the beginning. You want to make sure, particularly with things that, have a shorter lifespan, like video or audio surveillance, potentially, emails or instant messages that could be deleted. You want to make sure you're collecting those types of things right at the beginning of the investigation so that nothing is deleted, that you don't lose the ability to get something, and certainly so that you don't have any issues of spoliation if this were to go to litigation and then all of a sudden there's accusations that all of these things existed but now no longer do. And that can be the challenge sometimes with electronic materials that are maintained on things that are not necessarily work related, like home computers or personal electronic devices. So, it's not going to be, I think, the common circumstance that you need to necessarily collect those things. But certainly depending on, again, the type of complaint, the complexity of the complaint, those might be additional resources that you need to collect things from as well. And then one more thing I want to note here is that, again, where it is a situation that there's litigation involved, so, an EEOC investigation has been opened up or something like that, you're also going to want to send out a litigation hold to ensure that those who have documents that might be relevant to the investigation maintain those documents, and you can get a hold of those documents. And then the last slide here before I turn it back over to Ashley, you do also want to consider a plan to address retaliation concerns. So whenever someone brings a complaint forward, there's always sensitivity and concern around any potential for retaliation. So one thing to consider in sort of how to address this even before a complaint comes up is being sensitive to, is this an overall concern in the work environment? So are employees filing a lot of complaints? Do employees feel like they can come to managers, come to HR and express their concerns? If that's the case, then there might not be a huge concern around retaliation. On the other hand, if there aren't really, concerns that are being brought to managers, employees want to make complaints and raise concerns anonymously, then there might be a little bit more sensitivity around the potential for retaliation. So it's really important from the beginning of an investigation and certainly during the interview process to remind managers of the policy against retaliation and the importance of not taking steps that could be perceived as retaliatory, particularly by the person who filed the complaint. And then also for non-management employees, making sure that they recall and are aware of the fact that there is a policy against retaliation, and certainly they need to and should feel free to make these complaints without concern for retaliatory conduct. So with that, I will turn it back over to Ashley to close us out with special considerations for internal investigations.
Thanks, Lindsay. There are a few special considerations when conducting an internal investigation. Chief among them being maintaining the attorney-client privilege. And so we will go ahead and discuss that one in greater detail. It can be important to conduct internal investigations under privilege to give the company control over what information may be available to an adverse party in the future. It could be the case that your internal investigation is a roadmap to any deficiencies that are identified as a result of that investigation. And it's certainly not information that you would want the opposing party in litigation to have and be able to use. So to limit the possibility of the investigation and its results being used against the company, it is important to ensure that the attorney tasked with conducting the investigation does so with the goal of obtaining information for purposes of providing legal advice. As Lindsay mentioned, your investigation can be conducted by any number of folks, be it in-house counsel, outside counsel, human resources, perhaps it's a guarding expert or, some other sort of expert. What's important is that whoever is conducting the investigation is doing so and acting at the direction of counsel with the purpose of providing legal advice. And so it's important that counsel direct and supervise the investigation process, and that there is an element or component of the process where counsel is using their expertise and legal skills to perform the requisite assessments and make the final analysis and determination of the investigation. The attorney-client privilege applies when the investigation, is being conducted by or at the direction of counsel. And so one really simple way to think about privilege are the 5 C's, them being you have a client who is communicating confidentially with counsel for the purpose of counsel. And so, for example, if, in-house counsel is conducting the investigation, they are counsel, and they are communicating, and their client in this instance is the corporation. The interviewee is doing the communicating with in-house counsel, and that confidentiality is being maintained by ensuring that only those who are absolutely necessary and essential are participating in the investigation. And finally, the purpose of the interview is to determine the appropriate next steps for the company. With that being said, it's important to note that investigation-related materials must also show that their primary purpose is legal advice, and the privilege will not apply to communications that provide business or other non-legal advice, or legal advice that is merely incidental to business advice. So this is something that I think comes up pretty regularly with in-house counsel, who might wear both hats, as Lindsay mentioned earlier, attorney, but also providing, business advice. So something to be aware of. The more critical aspects of privilege is the ability for the company to maintain control of the dissemination of information that's collected during the course of the investigation. Excuse me. And so in the Supreme Court case, Upjohn v. United States, the court held that the general rule is that corporate attorney-client privilege does not cover communication between counsel and counsel's corporation, the constituent, meaning a manager or officer of the company, about things that fall within the scope of duties and where that information is exchanged for business purposes. it does apply when information is exchanged for purposes of providing legal advice to the company. So, for example, an attorney conducting an internal investigation with the goal of providing legal advice, be it how to respond to a charge of discrimination, be it whether or not, a particular piece of machinery needs guarding. And so in that instance, the privilege would apply. It is important to note here that the company controls the privilege and makes the determination about whether to waive the privilege and disclose the information. I know earlier Lindsay mentioned that, it could be possible that you do want to show the EEOC that you took those concerns very seriously. You did a thorough investigation and, what was determined as a result and what actions were taken as a result of the investigation. But it's important to know that the company controls the privilege and that they make that determination about whether or not to waive the privilege and disclose the information. Now, the company can lose the right of control if the interviewee claims that the company's lawyer represents him or her in their individual capacity, which could give rise to a personal attorney-client relationship between that in-house lawyer asking the questions and the person being interviewed. And this could have an impact on the ability of the company to disseminate what is discussed. Now, courts across the country apply different tests to determine when such joint representation arises. The prevailing approach favors the companies by placing the burden on the interviewee to show that they have taken steps to establish that personal attorney-client relationship. Under Upjohn and the attorney rules of professional responsibility that govern myself, that govern Lindsay, that govern all licensed attorneys, there's a requirement for corporate counsel to clarify the nature of the interview and that the purpose of the interview is for providing legal advice to the company and not to the interviewee. And this is accomplished by providing the warning that is listed here on this slide at the beginning of the interview. After articulating these warnings, the interviewee should be permitted to ask questions, should they have any. And ideally, depending on the nature, it might be best to have the interviewee sign a form indicating that they were, in fact, provided the warning, provided the opportunity to ask questions, and that they understand the Upjohn warning as provided. Some other considerations for internal investigations include where the investigation is conducted. So there are certainly advantages to remote interviews. For example, remote interviews could be a good potential option if there's a concern about timeliness and availability of witnesses and investigators and coordinating, everyone's schedule. Remote interviews could be a great workaround for that, especially if it's the case that witnesses and investigators are in different locations. So that flexibility could certainly be helpful. Likewise, interviewees may feel more comfortable in their own home and in their own space. That being said, nothing is all roses, right? So there are some drawbacks to remote interviews. For example, it will be more difficult to ensure that the interviewee is either alone in a room and in a space where they can expect a reasonable amount of confidentiality for the duration of their interview. Likewise, remote interviews raise concerns about sharing confidential documents and information, throughout the process. There's also, for remote interviews, it takes away some of those nonverbal cues that the person conducting the interview might rely on to assess the credibility and overall presence of the witness. Some other things that might come up is reliance on Wi-Fi and internet capabilities. So if, for example, the Wi-Fi connection is lost, you will want to have a plan to establish what to do, what those next steps are, and how to reconnect. Some other considerations include managing employee expectations, right? As Lindsay mentioned earlier, you are certainly going to want to follow up with the individual who filed the complaint, because it is certainly the case that if they don't hear anything, they might truly believe that nothing is being done. So it's important at the outset to manage those expectations, and not just for the individual who's filing the complaint, but for anyone who's participating in the process. You're going to want to think about employee morale and relations during the investigation. And you can do this by, explaining the process to the person who has raised the complaint, explaining the process to the person who is potentially being accused, and then explaining, to the witnesses their role, the process, and any follow-up that they can expect to receive from you. It's important that the interviewer maintain their credibility, and they can do this by not making any promises, to the complainant, the accused, or the witnesses, with the exception being, of course, they want to, make it very clear that the company is taking these concerns seriously and they are undertaking a thorough and impartial investigation. And then finally, as Lindsay mentioned, you're going to want to plan a description of the complaint that you're going to provide to interviewees. This description should provide just enough information to give context without validating the accusations against the accused, but not, any details that aren't necessary to the person with whom you are speaking. And then one final consideration before we close out today's webinar is the use of artificial intelligence. AI can be a great way to review documents, store and categorize information, and otherwise maintain institutional knowledge that is learned during the investigation. However, there are certainly some considerations for using AI. You're going to want to make sure that information is being reviewed and categorized in searches, where we're able to determine the source of the data. If you're using AI to filter out information, you're going to want to make sure that you're using appropriate search terms so that you are capturing the relevant information. And then finally, using the use of active learning technology to track how the investigation was conducted, including any information that was reviewed, any analyses that were used, and any decisions that were made intermittently by the investigators and the attorneys. And with that, we are closing out today's webinar. I'm not sure if Lindsay's had an opportunity to check the chat, but I do want to highlight some of our upcoming webinars in the future. I know during this webinar, we mentioned that, potentially wage and hour investigations. And so next month's webinar is hot topics and wage and hour law. We're also going to be looking in the coming months at marijuana and drug testing, which are also potential investigations that may be conducted as a result of a workplace incident or injury. So certainly something to keep in mind, as well as managing employee privacy rights. And then in the interim, please be sure to check out each of our blogs. We have the OSHA Defense Report, where we write about, emerging issues in the workplace safety and health space. Likewise, with our Employer Defense Report, our Cal OSHA Defense Report, and our MSHA Defense Report. And then the contact information for Lindsay and I. And then Lindsay, do we have any questions?
We do. We have a few questions in the chat. So I know we're a little bit over time, but we'll try to just touch on each of these quickly. So the first question I saw is there advice on when or if you have a witness or victim write up their own narrative of what has happened, or they saw or heard, versus the investigator preparing the statement from an interview and asking the witness to confirm the accuracy and sign it? So I guess from my perspective, I think generally you're going to want to go through the interview process. You can ask really specific questions, and the investigator sort of controls what actually, what's documented from that discussion. The times when it might be helpful to ask for a witness or victim statement is, when an incident occurs, if it doesn't seem, if it is, for instance, we see this sometimes in the context of like an accident in the work environment. If it's a situation where you really want to get the freshest recollection, get down exactly what each person saw and witnessed, and it doesn't seem like you will have someone who can necessarily meet with those individuals immediately, then it can be helpful to ask for an initial statement. But again, to the extent that you have in-house counsel or an attorney you're working with, it is helpful to sort of have that direction come from them, to the extent that you can then assert the attorney-client privilege over that process, that the person's being directed by counsel to provide information for purposes of an investigation. And then again, if it's the case, again, where it's more of the minor policy issues, we're a little bit less concerned about what's documented in writing and could potentially be available, to an opposing counsel if litigation proceeds or something like that. Those situations as well, I think it's okay to, ask for the narrative. And then you can certainly rely on the narrative to actually conduct an interview and ask more questions and get some more clarification. The next question, and Ashley, before I move on, do you have anything to add to that?
No, Lindsay, I think that's exactly right.
Okay. What are some of the best practices for others to ensure confidentiality? That's a really good question. A few things that come to mind are, first, you want to keep the investigation group really small. So the best way to preserve confidentiality and attorney-client privilege is ensure that information is only shared, or really the findings of an investigation, the piece that's going to really be confidential, is to ensure that the group is really small and only those that have like a real need to know are included in that group. The other thing to do is during interviews to remind people, if it is an interview or an investigation that's being conducted under attorney-client privilege, to remind the interviewee that the interview is being conducted under attorney-client privilege. That kind of goes back to that introduction that Ashley was talking about, related to, the upjohn requirements, and ensuring that, they're making best efforts to keep the discussion had during that interview confidential themselves. It's hard to sort of guarantee what anyone else is going to say, and you don't always know. But that is one way to sort of better ensure that that discussion is not had after the interview is completed. And then also sort of, marking emails that are exchanged about the investigation as confidential and attorney-client privilege. Again, it's going to be really an assessment of whether there is an appropriate privilege claim, based on the types of communications and whether it really is for purposes of preparing for litigation, going back again to what Ashley talked about. But it can be helpful to just sort of trigger in someone's mind that these are supposed to be communications that are kept confidential if you have that language in any written communications that you have.
Yeah, and Lindsay, if I may,
Mm-hmm.
some other possible considerations that I've seen work really well, before the investigation starts, once you have assembled your investigation team, you've determined who your investigators are, just having a kickoff meeting and, having a very open conversation with them about this attorney-client privilege, the purpose of their investigation, and what the expectations are for them as the investigator, right? Putting in those email communications reminders, do not forward, do not send this on to the next person, just so that, you're marking it attorney-client privilege and you are constantly reminding folks not to forward on any communications per that initial kickoff, where the expectations were laid out and set out clearly, and then leaving that door open for, if it's your HR representative, if it's your expert, whoever it is, to come back to your in-house counsel, your outside counsel, and ask any questions that they may have about who they can share information with, or what they can and cannot say, or how they should answer a particular question if it comes up during an interview.
Thanks, Ashley. Yeah, that is definitely really helpful as well. I've seen a couple times here the question about, can an employee refuse to participate in an interview? And so, the short answer is yes, they could refuse to participate in an interview. But most of the time, from my experience, what we see in employer policies related to sort of the complaint investigation process is, a standard of the expectation is that you will participate in an interview if it is necessary to do so. So there is definitely, the availability of taking some sort of disciplinary step related to refusal to participate in an interview. I don't think that's generally going to be anything particularly severe, but it could be sort of a written warning, a reminder of the fact that there is this set expectation. It's in the employee handbook, that the employee, if necessary as a witness, is expected to participate in the investigation process. You want to be careful about that, particularly related to, the complainant, for instance, because if the complainant refuses to participate in the investigation process and there is some discipline taken as a result, that could certainly be seen as retaliatory. At the same time, that person is very essential to the investigation process. And so, to the extent that they are refusing, or it could even be the case that they will participate, but they're refusing to give certain information or just share, maybe certain documentation that they have or something like that. That's going to ultimately weigh into the investigation process, and that should be something that's documented by the investigator. You want to make sure that it's clear that this is what the complainant was able to provide. This is what we relied on pursuant to our investigation. And, this is how we came out the way we did based on maybe the more limited information that we had, because they either refused or wouldn't provide certain information. So that's just part of the documentation and, any determination that's made as a result of the investigation. This could be a circumstance where maybe you try to work with the individual to see, is there a way that they would be comfortable participating in the interview process, and try to work with them on that, whether that, like I said before, if that's having like a coworker be present, or something along those lines. Again, that could potentially threaten the attorney-client privilege if that is something that you're worried about related to interviewing that particular person, but that could be, a way to sort of work around the initial refusal. Or really, I think it's also just having a discussion with that person as well about the reason for the refusal and trying to better understand it, to see if there is a way to sort of work with them. Maybe it's having someone else interview that particular person, someone that they feel more comfortable with, and seeing if there is a way to, sort of work with them to have their participation, particularly if it's, the complainant or a particularly important witness to the investigation. Another question: what if you conduct an investigation and can't determine if the accused is guilty or not? Unfortunately, I think that happens quite a bit. It's not always, a lot of these situations are not black and white. So I think what you are doing in that situation is determining, even if you can't determine guilt or not, have you identified areas of potential improvement or concern that you might be able to address? So one thing, that we've discovered in the investigation process is sometimes, maybe it's not clear that someone did something wrong necessarily, but they could improve the way that they do this particular thing. So maybe, it's not necessarily disciplinary action so much as providing training or retraining. In the context of a harassment claim, is there retraining that can be provided on effective communication? Maybe it's just there's a way that they're talking to some individual that seems problematic, and so it could be improved by some training or retraining on effective communication in the work environment or something like that. So even if you cannot determine conclusively whether this did or did not happen, there might be ways to sort of address any concerns related to the investigation so that the complainant sees that some step is being taken, even if it's not necessarily to discipline or terminate someone related to the complaint. And then I think there's one last question here. It seems almost any complaint in the context of the EEOC, OSHA, Department of Labor could give rise to litigation. It can get expensive to hire outside counsel for every claim. Is there another way to go? And that is it's a tough line to walk. I know for bigger companies, you can generally rely on in-house counsel as well, so it's not necessarily an additional expense. But that can definitely get tricky in the context of a claim that might be potentially filed with the EEOC or is ultimately filed with the EEOC. Does outside counsel need to be involved every time? I mean, it can certainly be the instance where you're not necessarily bringing outside counsel in as the investigator every single time, but maybe you're reaching out to them for general advice and counsel on how to navigate the investigation. That can be really helpful. As I think Ashley referenced related to the attorney-client privilege discussion, the investigation could also be conducted at the direction of counsel. So maybe counsel isn't involved in every single interview that's conducted, but they're directing human resources on how to conduct the interviews, what information to try to obtain, who they need to speak to so that they're involved, and the interviews are being conducted and the investigations being conducted for purposes of legal advice. But you don't necessarily have the attorney who is the only investigator involved in every single interview. So there are ways to navigate it while still potentially, being able to make those attorney-client privilege claims. And it's certainly, I will say in the OSHA context, I don't think it's necessarily going to be the case that you need an attorney involved in every single, investigation of a complaint related to a potential safety concern. I think it's probably really more the case if it's, a big issue, maybe something you've received several complaints on or something like, or can have a significant impact on the company, the outcome. But, I think that your outside counsel in those cases can really just be there more for advice and counsel on the issue. So I think that's all the questions that I saw. Thank you all so much for joining us today. I hope that this was a helpful discussion, and you will have our contact information through this presentation. So definitely feel free to reach out with any additional questions.